All right, ladies and gentlemen, this is Dave Wisniewski here at Tom Dean, attorney for Cannabis Law Office. Thanks for having me here, Tom.
All right, yep, Dave, you're welcome here.
Well, today we are talking about DUI, driving under the influence. And a lot of people have a misconception about Prop 207, thinking that it actually makes the situation worse. And Tom here wants to give us an overview of the history of DUI in Arizona and why Prop 207 actually makes the DUI situation better for cannabis consumers. Take it away, Tom.
Thanks, Dave. Yeah, it definitely does make it better. I'll tell you, for decades, and I've been practicing criminal defense here in the state of Arizona since back in the 90s, in the early 90s, early mid-90s. And going back as far as that and even before then, the law was, or at least the law that the courts accepted, was that a marijuana DUI could be based on the presence, solely on the presence of inactive THC metabolites. That's what we call carboxy THC. And I had many clients back then who were charged with this kind of DUI, who had last consumed marijuana maybe a month earlier at a party on a Friday night. But that's because these inactive metabolites can be detected for over 30 days, 45 days in some cases. So this is a very unfair situation. Unfortunately, it did go on for decades until 2014, a case called State v. Harris. Our Arizona Supreme Court finally agreed to look at this issue, whether or not these inactive and inert THC metabolites called carboxy THC could properly form the basis of an automatic DUI, and they said that would be absurd. Unfortunately, there was no relief for all those thousands of people who had been convicted over the years. But at least from that point forward, no one in Arizona has been convicted of a DUI based solely on having those inactive metabolites in their system. The problem was that the active metabolite, THC itself, and its active metabolite, which is called hydroxy THC, can still remain in the system for several days. And so for most patients who medicate daily or at least a couple times a week, they always have the active THC metabolites in their system, even though it's not causing them to be impaired. So every medical marijuana patient, practically, who got behind the wheel was automatically guilty of DUI if they got pulled over and blood tested. So although it was an improvement, it didn't really help patients very much. But that all changed in a case that I was involved in called State v. Dobson the following year in 2015. And at that time, the Arizona Supreme Court decided to examine the issue of how these marijuana DUI laws affected patients in particular. They agreed that patients should have an affirmative defense, specifically that even if patients have THC or hydroxy THC, its active metabolite, in their system at the time of driving, if they could persuade a jury that the nanogram level of THC in their system was insufficient to cause impairment, then that was a not guilty verdict. The jury could find them not guilty. And that was a huge change. But unfortunately, the burden was always on the patient to prove to the jury that the level of THC was not sufficient to cause impairment. Prop 207 now, 2020, fast forward, just 4 years, I should say. Before I get there, let me say this. After the 2015 case, State v. Dobson, that established the affirmative defense, we got a little help from the Arizona legislature. It improved things. For example, for decades up until then, Arizona drivers who were convicted of marijuana DUI had to install an ignition interlock device in their vehicle to have to blow into a device to make sure they weren't drinking alcohol before they could start their car. Well, that obviously was ridiculous, because what does alcohol have to do with someone who had a marijuana-related DUI? So they got rid of that. No longer is it required that a person who's convicted of a marijuana DUI has to install one of these ignition interlock devices in their car. Also, up until this legislation in 2016, a person convicted of a marijuana DUI had to have their license revoked for an entire year. That was changed now in 2016 to be like alcohol, which is a 90-day suspension, 30-day suspension, you can't drive at all, and then the 60 days after that you can drive for work or school. It's a restricted license. So a total of 90 days of suspension or restriction. That was a big improvement as well. And now in 2020, we are taking it one step farther with Prop 207. Prop 207 essentially looks at the same, the State v. Dobson case that established that a patient could beat a DUI if he could prove that the level of THC in his system was insufficient to cause impairment. It's now better because Prop 207 makes the state have to prove that beyond a reasonable doubt. So from now on, once 207 passes, the state will have to prove beyond a reasonable doubt that the level of THC in that person's system, that person who's over 21, was sufficient to cause that driver to be impaired. Not the general public, that driver in particular to be impaired. This is going to make it much more difficult for the state to prevail in a marijuana DUI case against anyone who's 21 years of age or older. So this is a huge victory for marijuana consumers, for cannabis consumers, almost all of whom at one time or another are going to be behind the wheel. So this is a definite improvement. And if anyone thinks that this is in some way making things worse, then they really don't understand what the law is right now, or what the provisions in 207 provide.
Awesome. Well, thanks for clearing that up, Tom.
You bet.